afternoon's virtual student event, SQE, how well can you tackle MCQs with BPP? Thank you all very much for joining us. This event will run from 4 until 6 p.m. The first hour will be a practical SQE workshop led by BPP's Head of Outreach and former City law firm partner Johnny Hurst. If you want to leave a comment during the session, please do make sure that you have set your chat to stage so that we can all see them come through. But you might want to save your questions for the second hour, which will be a virtual networking session over in the expo booths. So make sure you hang around until then to chat with BPP Law School team for follow-up questions and further careers advice. So without further ado, I think I'll hand over to you, Johnny. Thank you very much.
Thank you so much. And it's a pleasure again to be here presenting a session to a number of prospective SQE students. We at BPP have been running many of these sessions over the course of the last 3 or 4 years because there's a massive information vacuum about the SQE, what it involves, and that's why we're here today. There's lots of stuff that we partner with Legal Chic on in terms of the website that Legal Chic has. We are the custodians of the FAQ section on the SQE, amongst other things. So what we're going to cover today, well, that's what it says on the tin. We're going to see how well you can tackle MCQs on LLB or law conversion course PGDL, GDL subjects. So I'm assuming that most people, but you don't have to, but most people will have had at least 1 year of experience on a LLB. But if you're a law converter, don't worry, stick with us and give the questions a go. And the reason why we're doing this is because a significant amount of what's covered on a law degree and a law conversion course still has to be retained for the purpose of the SQE. So it's a good idea to see the SQE, how it examines some of the stuff that you might already know. And that's the purpose of today's session. Before we go any further, let's just give you a bit of an overview of the SQE pathway, just to remind you. In order to attempt the SQE, you have to have a degree or equivalent, not necessarily a law degree, but responsible SQE providers require you to have a law conversion course before you start one of our SQE 1 preparation courses. And the reason for that is going to become apparent when you do these questions. If you're a law converter, you might be able to guess 1 or 2 questions, make educated guesses, but you need a really thorough course to prepare you to get yourself to the same level as an LLB graduate. Otherwise, you'll be setting yourself up to failure. I know there are lots of courses out there that promise you the earth where you can convert within 2, 3, 4 weeks. Compare that to a course that you spend 6 to 8 months converting as a full-time student. It's a no contest in terms of how thorough you're prepared to catch up the LLB graduates. It really is something I can't recommend strongly enough. If you're a law converter, do a full conversion course, not a quick prep conversion course, because you'll set yourself up to failure. Anyway, the SQE pathway is you have to take SQE 1 first, you take SQE 2 if you passed SQE 1. At some stage during your journey, you need to complete 2 years worth of qualifying work experience. If it's at one particular employer, that's often called a training contract, as you know. You can do your QWE before, during, or after your SQE exam journey. It doesn't matter, or a combination of, you can work for a bit, do a bit of SQE 1, do a bit more work experience, and then do SQE 2. It really doesn't matter what order you do your work experience in, but what is important is that you can only take SQE 2 after you've passed SQE 1. So we're going to focus on SQE 1 in today's session and look at the multiple choice papers. So you have to answer 360 multiple choice questions that are set roughly a week apart. And they're set on a whole variety of black letter law areas, many of which you've covered in your law degrees, like the ones you can see on the screen now. So landlord, trust and criminal law, contract law, tort, legal system of England, Wales, constitution, administrative law, EU law and legal services. These are subjects that by the time you finished a law degree or a conversion course, you will have covered these subjects. So it's absolutely essential that you keep these subjects warm as you go into the SQE. And for reasons we'll explain in a few moments' time, that the SQE preparation courses don't reteach you all these areas. You are deemed by pretty much every SQE prep course to have these already in the bank. There's lots of support that we at BPP provide for our students to revise these areas, but we won't reteach you everything from scratch because you've already learnt those and it'd be wasting your time. But revision is really important to this. You do partly on your own terms, but partly with us in revision sessions. So this black stuff here that you can see, the black letters, are what you get taught on any SQE preparation course. This is all the practice areas of business, dispute resolution, property practice, wills, administration of estates, criminal practice, solicitors' accounts, and so on. So there's a combination of subjects that are set across these two papers. You get 180 questions on one day, 90 in the morning, 90 in the afternoon, and you do the same about a week later for the second paper. And what we're going to focus on today is some of the questions that are coloured in blue there, because these are the questions that most people who are on this session at least have some working knowledge of, because you studied some of them as part of your law degree. But even if you haven't and you're a law converter with a non-law background, stay with us. It's always useful to learn something along the way. Start kick-starting your preparation now and your conversion now. So that's SQE1. In terms of the SQE1 assessment, there were lots of questions that were asked in advance of the session. I'm just going to cover these off now before we have a go at some of the questions that are on the SRA's website. The format and content is something that I've just mentioned, that SQE1 is just multiple choice questions. So we were asked to explain that. I think we've covered that. We've also been asked to explain how relevant your LLB materials are for the SQE1 exams. I think I've mentioned that in the sense that you do need to retain your LLB materials. We at BPP also give you lots of revision materials as well, but I would suggest keep yourself warm with the LLB subjects. If you're looking to start an SQE course, say in September, go back over all these but-less law areas. They will stand you in good stead, because you do need to revise them at some stage before you sit SQE1. This question I put in yellow here because I haven't answered this yet. How does the single best answer format differ from traditional law exams? So just to be clear, when we're going to look at the SQE1 questions in a few minutes' time, they're multiple choice questions with 5 options, and all the options are plausible. This is what we mean by single best answer. There's not like obviously wrong answers if you just looked at the answers on their own. They all could be the right answer if the scenario and the question were asking you something specific, but one of them is objectively the single best answer. So the bar is much higher than some multiple choice questions you may have received in the past, where some answers you can dismiss almost immediately. The standard that you're expected to get to, which is a day one qualified solicitor, means that single best answers really raise the bar of the analysis you need to do to get yourself to the right answer. And the other question on sort of the exam format we were asked about in advance was, how can students effectively balance the breadth and depth of the course when preparing for SQE1 in the areas of the law they find most challenging? You've seen there are so many different areas there. The advice for you is, if you go to a responsible, reputable provider like BPP that give you an in-depth, in-person experience with a substantial amount of materials over quite a long period of time, trust the product of the provider you commit to, because ultimately they will take you on the journey you need to. For example, with BPP, where you're finding stuff most challenging, when you're answering questions online to prepare for your classes, the system will know through the AI learning we have where you're weaker, and it will send you more of the same subjects until you get up to a level where the AI says, actually, you're at a level now where we can leave you alone on that subject. So we've got the software to support students with the areas they find most challenging. So that's certainly something that I'd recommend that you're looking for in an SQE provider. Before we look at the 10 questions we're going to focus on during the course of this first hour, I'm just going to give you a bit of an anatomy of SRA sample question. This is a question that's on the SRA's question bank, and it's a contract question. I'm not going to answer the question now. You can go away and work that out for yourselves, because most of you have done contract law. But I want to explain to you just how these questions are set out. You'll get 360 of these, and they'll all follow a very similar format for SQE1. And what you'll see right at the beginning is what we call the stem. It's the scenario, basically, that gives you the factual background before the question that's going to be asked. And the SRA call this the lead in, but it's effectively the question you've been asked to apply whatever the facts are in the fact pattern in the stem. And then you're given the 5 different options to choose from. The correct option is going to be one that obviously you've got to find, but there are 4 distractors. And those 4 distractors, as I mentioned a moment ago, they're there really to challenge you, because if you remember your contract law, forget about the fact pattern, all these options here could be the right answer if the fact pattern was worded in a particular way. So none of them, if you just look at them on their own before you look at the fact pattern, are necessarily going to be wrong. You really have to look carefully at the nuances in the fact pattern to get yourself to the right answer. And the key to this, to answering any sample MCQ correctly, and all of the questions in the exam, is, I say, to literally have a conversation with yourself as you're reading it through. And if you go on, I've got my own personal project called SQE TV. Check it out. There'll be a link later on. But what I do is I go through a strategy of how to analyze every MCQ that you come across. And it's like having this conversation with yourself just to summarize what you've read, what you're thinking about, rather than just read it and then hopefully try and process it all together right at the end of reading the question. There's so much information there to unpack in the stem. What you should do is almost do a mini pause after each thing. So I'll give you an example here. A man is given a gift as a bicycle. Okay, given a gift. He later agrees to sell the bicycle for £25 to a woman, but no payment has yet been made. So I'm thinking this is sounding like it might be a contract question. He subsequently discovers that the bicycle's worth £390. So he's obviously sold it as an undervalue, is what I'm thinking here. Is that going to be relevant? Don't know. He informs the woman that he no longer wishes to sell the bicycle because he was mistaken about its value. So it's all centered about, yeah, is he going to be committed to this contract? And it's sorry, is the woman committed to this contract? So, what advice should the woman be given? And I'm not going to go through the analysis here, but I will do it for the other questions we look at. But you've obviously got to go through these each in turn and have a conversation with yourself as to why you're ruling something in or out, or if it's a maybe that you'll come back to. Because remember, some answers there might be 2 or more answers that look right, in which case you're going to have to choose which is the better answer, because sometimes 2 of the answers might be objectively good things to do, good advice to give, but one of them is just going to be slightly better. So always have that conversation with yourself as to why you're ruling something in or ruling something out. So with that in mind, just to say, on the chat, if we could just restrict the chat comments, please do. Uh, not network anymore with your LinkedIn profiles. It's time and place for that, but let's just keep to the subject matter now. And thank you very much, Veronica, for complimenting my YouTube channel, SQE TV. Oh, you said it's been amazing and helpful. Oh, that's really nice. Well, yeah, do check it out, folks. It's becoming very popular. It's my own independent project of BPP, and it helps students prepare for all the decisions they need to make with SQE, but also gives you some help with analysing questions like we're doing today. So, without further ado, let us have a look at our first question. And what you're going to do is I'm going to read through the question and I will set my stopwatch. And I will set my stopwatch with the amount of time that you have on average to answer an MCQ. Don't put the answers in the chat, please, yet. You may be right, you may be wrong. Don't put the answers in the chat yet. Hold on, hold on, hold on. We're going to have polls that we're going to release. And people are putting different answers there. So some people have put B, some people put E, some people put D. So don't put the answers in the chat. Put your answers in the polls. Don't chat about it on the chat. I want you to have your own uninfluenced decision that you make, because it's easy to be persuaded by the herd, and the herd might have got the wrong answer. And certainly some people have got the wrong answer, because there's at least 3 answers that have been suggested in the chat. We're going to release polls in a moment for each of the questions. But my first question for you, where you can answer in the chat now, is how long on average do you have to answer an MCQ for SQE1? Do you know? Does anyone know? How long on average do you have? Anyone idea? I know there's normally a little bit of a delay, so I'll wait for a little bit for somebody to come up with an answer. Just to say, this is on average. You don't have the same amount per question in the exam. If you only take a short time for one question, that means you've got more time for the later questions. So we've got Sogdiana says 1.5 minutes. Leanne says 1 minute. Alex is closer with 1 minute 30. Nobody's got the right answer yet. a lot of people are around about 1.5 minutes. It's actually 1 minute 42 seconds on average. So 1.5 minutes is about right. I'm going to give you 1 minute 42 seconds, which is I think 1.7 minutes to answer the question that's coming up. And I'll include that. The time is going to be included from the time I start reading the question. No. So before we go through the question, though, just to remind you, these are all questions that most first or second years will have studied on their LLBs or a law conversion course. These questions are going to be on contract tort, administrative law, or legal system of England and Wales. And other things to mention you in the poll section in the platform, please attempt each MCQ by selecting the relevant option and keep a score of how many you get right, because we'll compare that at the end of the exercise. So you'll have 1 minute 42 seconds, as I mentioned. I'm going to set my stopwatch now, and from the time I start reading the first question, you will be able to answer it. But if we could have the first poll released, please, that would be great from the Legal Cheat team. And once you are happy to select your answer, make your selection. So keep a tally of how many you got right, as I said. So here is the first question. Clock starts now. The owner of a Greek restaurant orders wall tiles that includes a border design showing the Greek flag. After the tiles have been fitted, the owner notices that the tiles are decorated with the flag of Uruguay. The owner wants the tiles to be replaced. In a claim for breach of contract, which of the following measure of damages is the court most likely to award? Expectation, reliance, cost of cure, loss of amenity, or mental distress. And just to remind you, please use the polls now that you can see on the right-hand side of the screen. Don't put your answer in the chat. So this is the answer for question 1. Off you go. So you've got just under a minute left to make your decision. Read through the question again, break it down. Just do the best you can if you're not sure. As well as selecting the option, you do need to submit your answer. To select submit answer. So we've got lots of people made their selection so far, but still quite a few to make the selection. You've got about 20 more seconds left. Okay. And we'll stop the clock now. So that's the end of that question. So interestingly, the most popular answer with just over 50% of the votes is option C. And I'm pleased to say that option C was the correct answer. But only just over 50% of you got that right. So what's that all about? Now, this was a breach of contract question. And this is about putting and remembering that when you're compensating somebody in a breach of contract case, the position that the innocent party wants to be in is as if the contract had been performed. So effectively, if they got the wrong flag, what we need to have is the cost of actually changing the flags to the flag of Greece rather than the flag of Uruguay. So it's the cost of the cure. That's basically what the level of damage is going to be to put the innocent party, the owner of the restaurant, in the position that they would have been in. So well done if you got that right, roughly half of you. But if you didn't get that right, don't worry. Keep a tally of your score. We'll move on to the next question now. Well, we've got another 9 of these, so we'll be dotting around between different subjects because that's the way that it goes with the SRA's SQE. They don't do a chunk of contract questions and then a chunk of something else. Literally, you've got to be quite agile between subjects as you go through the exam. So let's go to question 2. If we could have question 2 on the MCQ poll up as well, if you could answer it in the question 2 poll. Question 2 is, I'll start the clock now. A decision is made by the Court of Appeal, Civil Division, in favour of the claimant. The defendant wishes to obtain permission to appeal. Which of the following courts have the power to grant permission to appeal? The Court of Appeal only, the Supreme Court, the House of Lords only, the Court of Appeal and the Supreme Court, or the Court of Appeal and the House of Lords. So poll 2 you need to answer now to answer this one. What we normally get is a bit of a fight between two of the options here. And this is something you either know or you don't. Got about 30 seconds, just under 30 seconds to go. So it's about 10 seconds to go. So make your selections now or forever hold your peace. And we're done. And I'm very encouraged to see that, again, around about 50% of you, just over 50%, a little bit more, but under 60% of you got the right answer here. And the answer was option D. Well done if you got that right. So this was quite a discrete question in terms of piece of knowledge. And sometimes it's just testing knowledge, these questions. Other times you're having to work stuff out from the fact pattern and apply the facts. But this is really just asking you, it's a bit like a trivia question that you either know or you don't. Yeah, if you are applying um, for uh, for leave to appeal, where can you make your application? So which court has the power to grant you that appeal? Well, it's both the Court of Appeal and the Supreme Court. So you can apply to the court from which you are appealing, as well as the court to whom you are hoping to have your appeal heard. That's the discrete bit of knowledge. Didn't require an awful lot of brain power in terms of working stuff out. It's just, as I said, you either know it or you don't. So we're giving you exposure to different styles of question here, stuff that's just knowledge based, stuff where you've got to piece together bits and pieces to get to the right answer. So well done if you got that one right. Let's now move on to the third question. And I'm going to set my stopwatch again. Off we go. And if we could have question number 3 up, please. A man runs a very popular farmers market on a small farm on the edge of a village every Thursday. This results in the village becoming very busy on Thursdays, when many of its roads are blocked by parked cars. Because of this, on Thursdays, a woman who runs a business in the village is unable to deliver her goods and she loses trade as a result. Which cause of action should the woman pursue in tort? Private nuisance, public nuisance, Rylands and Fletcher, negligence, or occupier's liability? I think this is quite an easy question if you can remember your tort module. Let's see how you're getting on. You've got about just under a minute to go. About 30 seconds just to process that fact pattern again if you need to. Okay, well, I'm pleased to say my thoughts were much better. 2/3 of you have got the right answer here, so well done. You obviously gone to very good law schools. The answer to this question is that it's a public nuisance, option B. The reason for that is that the wrongdoing, the tort here, is happening in a public space on public highways, and therefore the action would be for public nuisance, because that's where the nuisance is actually taking place. It's the tort of nuisance, and it's a public nuisance because it's happening in the public highway that all members of the public are being affected by. So if you got that right, well done. These questions, I think, are going to get a little bit harder. This did require a little bit of processing, because, of course, if this the fact pattern was slightly different, then it might have been a private nuisance, but not the case here. You could rule out the other three, C, D, and E, hopefully quite quickly. Rylance and Fletcher's about, if you remember that, that's the tort where you have an escaped substance, naturally occurring substance that escapes from one piece of land to another. So that's not relevant on this fact pattern. The tort of negligence. There's nothing about a duty of care to stop somebody incurring injury, which is what would happen, or loss. There's nothing like that happening for option D, and it's not an occupiers liability situation where somebody's had an accident on your land, which is what would trigger occupiers liability, for example. So public nuisance would probably quite easy to arrive at by the majority of you. But well done if you got that. But don't worry if you didn't. What we do at BPP is to give people refreshers and materials to revise these areas. But just to reiterate, you don't get retaught these areas from scratch. A lot of it's down to you, which is why I suggest that if you're going on to an SQE prep course, you start revising these areas once you've finished your third year exams and had a bit of a break, and which I suggest you do before you embark on the lead up to SQE. Right, let's have a look at question 4. A claimant is bringing a claim against. Oh, I need to reset my clock. Let's do that. Sorry. A claimant is bringing a claim against a defendant seeking damages for breach of contract. The claimant alleges that the parties agreed to an oral amendment to the contract. The defendant denies that the parties had any such agreement. The only evidence on this issue which will determine the outcome of the claim is the conflicting oral evidence of the claimant and the defendant. Which of the following best describes the burden of proof, if any, which the court will apply in deciding the issue? So A, the burden lies with the defendant to disprove the claimant's allegation beyond reasonable doubt. B, the burden lies with the defendant to disprove the claimant's allegation on the balance of probabilities. C, neither party bears the burden of proof, and the judge will order a retrial if the judge can't be sure which party's evidence is correct. D, the burden lies with the claimant to prove the allegation on the balance of probabilities. Or E, the burden lies with the claimant to prove the allegation beyond reasonable doubt. So hopefully you've started to vote for question 4, which should now be on the screen for you to vote. Got about 20 seconds to go. Okay, and I'm pleased to say, as I thought, this is a question that most people should be getting right, because having done and learnt about the burden of proof, where that lies, and what you need to establish. Yeah, there's a difference between criminal and civil cases. In civil cases, you have to prove your case if you're the claimant on the balance of probabilities. In a criminal case, the prosecution has to prove their case beyond all reasonable doubt. But this was a civil case, and therefore option D was correct. The onus is on the burden is on the claimant to prove the allegation on the balance of probabilities. In other words, it's more likely than not that there was this amendment to the contract, or the oral contract that was in place. They just need to prove that the terms in that contract are accepted by the court beyond the balance of probabilities. So yeah, 2/3 if you got that right, just under 2/3 Oh no, actually, it looks like two-thirds of you now. It might have changed since I gave you the answer, but never mind. Okay, so good stuff. Pleased to see that I think quite a few people have got all four questions right so far. There are going to be some harder questions. Don't worry, and don't think that the SQE is easy if you've got 4 out of 4. It is not. I've given you some questions that I think are on the easier side because what I don't want to do is to scare people into thinking the SQE isn't achievable. There are lots more harder questions than the ones I'm going to show you, but it should give you confidence that if these are sample questions, which they are, then you should be able to have confidence that you can go into a prep course at a decent provider with a realistic prospect of passing. Okay, question number 5. A junior employee at a summer camp for young people has been convicted of an assault on a participant in the camp. The victim suing the camp organisers for damages for psychological trauma on the basis that they are vicariously liable for the actions of the employee. Which the following best describes whether vicarious liability will apply? A. Vicarious liability will apply if the employee's act is sufficiently closely connected to his employment. B. Can't apply to criminal behaviour. C. Vicarious liability will apply if only if the assault occurred in working hours. D. Vicarious liability can only apply to senior employees. And E. It will not apply because the employer obtained no benefit. So you've got just under a minute to work out the answer now to question 5. Got about 20 seconds to go. Quite a few of you need to make a decision. This is where it gets a bit trickier. Just have the best stab you can. You never know, you might get right. See what you can rule out and flick a coin between 2 or 3 if that's the case. If you can't flick a coin between 3, I don't think you can, but you know what I mean. Okay, final chance to make your decisions. Okie dokie. Well done, those of you who have voted. Again, quite good answers, quite good replies here. The correct answer is answer A. Vicarious liability will apply if, and this is only if, the employee's act is sufficiently closely connected to his employment. So we can, so looking at B, it can apply to criminal behaviour, but provided that it's closely connected to the employment. So that's why B was wrong. There's no limitation on whether it occurs during working hours, but of course, if it's outside working hours, it's less likely to be connected to the employment, but not necessarily completely. Yeah, that's why we think A is a better answer to C, because you could envisage a situation where, something might have gone beyond working hours, where it's still closely connected to the employment. D, vicarious liability can only apply to senior employers. No, not just limited to them. It's for everyone, and the benefit or not, as the case may be, that the employer obtains is irrelevant for option E. So A was the correct answer, and well done to the 70 odd percent who got that one right. So this is doing really well. All right, let's now go on to look at some more, which are getting a little bit harder. Okay. A company buys industrial cleaning acid from a woman and stores them in its factory. The drums are not suitable for the storage of the acid, and the acid leaks, causing damage to the floor of the factory. A company employee sees the damage to the floor is being caused by the leak but fails to move the drums. The drums could have been moved at no cost to the company. The company claims £5,000, which is the cost of the repair to the floor. The woman refuses to pay that amount, arguing the damages payable should be lower. Will the woman succeed in her argument? And you got option A, yes, she can succeed because the company is under a duty to minimize its losses by moving the drums. B, yes, because the company is guilty of contributing negligence by not moving the drums. C, no, because the company must compensate the woman must compensate the company for all losses flowing from the breach. D, no, because the woman must compensate the company for all losses that are in the reasonable contemplation of the company. Or E, yes, because there's a break in causation. You've got about 40 seconds or so. This is question 6. Got about 5-10 seconds to go, so make your votes. It's harder, this one. I can see people are really finding this one a bit of a struggle. Have a go. I'll give you 10. I'll give you extra 10 seconds because this is quite a longer one and it's trickier. So we're up to 2 minutes now. So sometimes you need to spend a bit longer, and this is quite an interesting. I'm still letting people vote. It's quite an interesting one. People were struggling on this, and it's fine because a lot of you would have got through some of these questions much quicker than the average 1 minute 42 seconds I've given you. So it's fine where you're struggling with one or think I need to think about this one for a bit longer. As I expected, and I'm just going to show you the results here. There is a real tie in terms of. Hopefully you can see this now. There's a real tie between A and B as being the most popular answer by a long shot, although there were quite a few answers for C, D, and E as well. So why is there an issue here, and why is the correct answer A and not B? Because that is the correct answer. So what's happened here is that the woman's actions didn't cause the damage. The damage was caused by the leak. So the woman can't be contributory negligent, but what she should have done, sorry, the company isn't guilty of contributing negligence, but they should have moved the drums, which would have mitigated their losses. Because if you are in a breach of contract situation, you suffer loss, you, generally speaking, have a duty to mitigate your losses. In other words, to take reasonable steps to avoid greater loss than you could otherwise do. And therefore, once the company was aware that the damage was happening, the drums really should have been moved. So if there was damage caused up to that point, that probably is going to be the level of the damages that they can recover. But if further losses were incurred because there was a delay or they didn't move the drums, in that sense, there's not going to be a full recovery from the company in that situation. So it's about mitigation. It's not contributing negligence because the damage itself wasn't caused by the act or omission of the company in this case. The loss and the extent of the loss is caused by them not taking action, but that's different. But it's not contributing negligence. It's about a failure to mitigate. So only about just over a quarter of you, or third of you actually, 30% or so got that one right, but well done for those of you who did. Let's have a look at MCQ 7. Hope you're enjoying this so far. Right, MCQ 7. Let's put our clock back. A man is employed by a roofing company to repair roofs. The role requires him to wear special gloves in order to protect his hands when he handles roof tiles. When standing on some scaffolding, negligently erected by the roofing company, he falls off, suffers serious head injury to his head, and brings a claim. He carelessly failed to wear the gloves at the time. Which of the following best describes whether the company can successfully claim contributory negligence on behalf of the roofer? A, the company can't claim contrib because the roofer's carelessness didn't cause or contribute the injury. B, the company can't claim contrib because the roofer didn't owe the company a duty of care. C, the company can claim contrib because the roofer's carelessness caused or contributed to the injury. D, the company can claim contrib because the roofer's carelessness materially increased the risk of injury. And E, the company can claim contrib because the roofer owed the company a duty of care. You've got about just over 30 seconds. And again, we're taking a little longer on this one, a bit like the last question, where it's just a little bit harder. This really does require you to deconstruct the fact pattern. So I'm giving you a little bit of extra time here for those who still need to get a vote in. You have to deconstruct this fact pattern and almost build it back up again. So just make sure you've got all the points, which is why when I suggested earlier, you break down each part as you're reading through it and analysing it. Okay, I'll just give you another few seconds to make your votes. But I'm pleased to say we've got around about 2/3 of you getting the right answer, which is good to see. Okay, so we've got the results in. About 2/3 of you got the right answer, which was A. Well done. Now, what often trips people up on this, and this is the type of question where you need to piece things together, where in a different situation, the answer would be a different option. What caused the injury here wasn't the gloves. Even though he carelessly failed to wear gloves, what caused the injury was the negligent erection of the scaffolding. So, although there would be contributing negligence had he injured his hands in a bad way by not wearing gloves, if he was, say, handling roof tiles and they cut his hands, but that's not what caused his injury. What caused his injury was the scaffolding that fell off and he sustained injuries to his head, not to his hands. And on that basis, you can't say that the other popular answers were that, like D was quite popular amongst the people voting. The company can't claim contrib because the roofer's carelessness materially increased the risk of injury. It is true that he was careless and he did risk greater injury by not wearing the gloves, but he suffered a head injury and therefore the gloves isn't going to make any difference at all by the sounds of it. So clearly, what's the single best answer here is the company can't claim any contrib here because not wearing the gloves, although he should have worn gloves, not wearing the gloves hasn't caused the head injury. It was the negligent erection of the scaffolding. Hopefully that makes sense. And if you want to see a further reconstruction or deconstruction of the question, go on my YouTube channel, SQE TV, for analysis of that, because I think we do have a look at this question. Right, let's have a look at question 8. We've got another couple of questions to go, 8, 9, and 10 to go. Off you go. So, question 8. The UK government's introduced a parliamentary bill to repeal a UK statute. The government's able to command a majority in the House of Commons, but the bill is opposed in the House of Lords. The Parliament Acts 1911 and 1949 are invoked in order to pass the bill into law. What further steps are required for the bill to become law? A, the bill will require approval in the House of Commons and to receive royal assent. B, the bill will require approval in the House of Commons and the House of Lords and to receive royal assent. C, the bill will require approval in the House of Commons, and a UK referendum. D, the bill will require approval in the House of Commons, the House of Lords, and in a UK referendum and receive royal assent. E, the bill will require approval in the House of Commons, the House of Lords, and in a UK referendum. Vote now. Got about 40 seconds. About 20 odd seconds to go. I can see a few of you still to vote. Again, this is probably something you either know or you don't. And if you can't remember what the Parliament Acts are, that obviously is going to cause you a bit of an issue because it all turns on your knowledge of your understanding of what those acts deal with. Okay, we've reached the time, but I'll give you another 10 seconds because there's still quite a few people who haven't had a chance to vote yet. Okay, well, before I give you the answer, just looking at some of the red herrings, the distractors in there. So requiring a UK referendum isn't required every time the government gets a bill opposed in the House of Lords. You don't need to put it to a UK referendum, so that was clearly a red herring. Reference to the House of Lords is no longer relevant. It's the Supreme Court, which is the um, sorry, I beg your pardon. Beg your pardon. Reference to the House of Lords is something uh, that this question turns on. Do you have to get the approval of the House of Lords or not? And if you look at the results, the two most popular options were A and B. So the question is, everyone agrees you need the bill passed by the House of Commons. Absolutely true. Everyone agrees that who chose those options that you need royal assent, but do you need House of Lords approval? And to select the right answer, which was option A, meant you needed to have an understanding of what the Parliament Acts were. And this is a procedure by which, I think normally following 12 months, you can pass into law a bill that hasn't been approved by the House of Lords, so they can delay it, but not indefinitely. So ultimately, the bill will only require approval in the House of Commons and to receive royal assent, having waited the year or so after it's been rejected by the House of Lords. So in that sense, about 40% of you got that right, and about 50% of you, just under, chose option B. So you were very close, but no cigar on that one. So you don't always need every bill to be approved by the House of Lords because the Parliament Acts can be invoked, particularly if a government doesn't command a majority in the House of Lords. Okay, well done if you got that right. Two more questions to go. Question 9 now. Here we go. A local council introduces a ban on school-aged children entering coffee shops, shopping centres and cinemas between 8 a.m. and 6 p.m. on school days. The decision is an attempt to reduce high levels of truancy in city centre schools. It's made under legislation giving local authorities full discretionary powers to introduce measures aimed at improving educational attainment and is introduced without public consultation. Local businesses are outraged by this decision and seek legal advice. Many of them rely on the trade from local school children, and since school lessons finish by 3:30, they can't see how the ban until 6 p.m. can be justified. No human rights issues are at stake. Quite a long fat pattern, this one, isn't it? Which of the following statements best describes the basis upon which this decision could be challenged through judicial review? A, if the decision doesn't give sufficient weight to the interests of local businesses. B, if the decision does not result in demonstrable improvement in educational attainment by local school children. C, if the decision is one which is not the most cost effective in the circumstances. D, if the decision goes significantly beyond what local authorities are doing elsewhere to address the same issue. Or E, the decision is so outrageous it's in defiance of logic and no sensible person could have arrived at it. So you've got taking me 20 seconds to read through that. Sorry, 1 minute 20. So it only gives you 20 seconds to make a decision. See how you get on. I'll give you a little bit longer for this one because there's quite a lot to process. Okay, we've come to the 2 minute mark. Carry on voting. Give you another 10 or 15 seconds on this one because it was a much longer fact pattern. And you'll see that we've given, there's quite a lot of variety in the length of questions, as you've seen. Some have long options, some have a long stem, that fat pattern. This one's relatively long. Okay, I'll give you another 5 seconds or so. Last orders to make your vote. Okay, well, so this was about judicial review. So administrative law is what's covered in this question. And the correct answer was that just over half of you got right. So well done for you. Was that option E was the basis upon which the decision could be challenged in judicial review. It's so outrageous in its defiance of logic that no sensible person could have arrived at it. And what you needed to do to get this right was to appreciate that the basis upon which the decision is made defies any logic, because the school children finish their lessons by 3:30, but the ban's in place after they finish at 3:30. Obviously, it's in the public interest to make sure that there's a ban before 3:30. I get that, because they should be in school. but it doesn't make any sense to extend it beyond 3:30, and that was the point. So that hopefully explains why you would have got to that particular answer. All the other points might be relevant in the consideration by the local authority, but what ultimately the local authority would make their decision on would be upon the basis of here on these facts anyway, what a sensible person would have arrived at, and no sensible person could have come to that decision by any logical means. So well done if you got that one right. Right, we're in the home straight now to the last and final question. Keep a tally of how many you've got right so far. Last question. A woman works for a local charity for disabled people. The main function of the charity is to arrange transport for disabled people in and around the community. The charity uses one particular firm of taxi drivers to carry out this function. The woman reads in a newspaper about recent legislation which requires taxi drivers to help disabled people when using their taxis. The woman looks up the legislation and finds as follows: Taxis and Private Hire Vehicles, Disabled Persons Act 2022, and then it's listed under that 2022 Chapter 29. An act to make provision relating to the carrying of disabled persons by taxis and private hire vehicles. And then in square brackets, it's got 28th of April 2022. The woman wants to know what is the significance of the 28th April 2022 and telephones the charity solicitor for legal advice. What should the solicitor advise? So it's all about the date. What's the 28th of April 2022? A, that it's the date the most recent draft of the statute was presented to the House of Commons. It's the provisional date for this statute coming into force, or it's the date the statute received royal assent, or it's the commencement date of the statute, or E, it's the date on which the statute passed its committee stage in the House of Commons. So have a go at that one. Again, this is probably discrete knowledge that you're more likely to know or not. It's not one that particularly requires working out and dissecting the fact pattern quite like the other ones. So you've had your time now. So if you could just make your vote, I'll give you another sort of 20 seconds of extra time because it was quite a long fact pattern on that one. Another 20 seconds or so. Okay, so we've had all our answers in, more or less now. So let's have a look at the right answer. Well, I'm pleased to say that 49% of you got the right answer, which of course was C. That's the date that the statute received royal assent. As I said, it's either something you knew or you didn't. So sometimes it's just a question of reading through the fact pattern and just understanding what the question's asking you and then remembering the answer from what you've learnt, or at least selecting the most appropriate answer. This was a discrete piece of knowledge that was tested, not something that required any particular application of the facts to the law to the facts. It was just whether you knew it or you didn't. So well done, folks. That was your little amble through the MCQs. Before we find out how you've done, in a word, share with us in the chat one word that sums up how you now feel about the SQE1 assessment. Always interesting to see a knee-jerk reaction and response to how you feel it went for you. So tell us in the chat, in one word. In one word. Ellie, I'm sorry, unless you were totting up how you did as you went along. I'm not sure you'll know, but roughly tell us how many you think you're right. So let's have a look at in a word. What do you now think about the SQE? Just having a look to those questions. Good. The answers are starting to come in. Val says manageable. Redmond says confident. So Dion, I'm really interested about responsibility. I'm interested to know what you meant by that. Doable says Tiago. Emily says tough. Veronica says terrified. We've got challenging, informed, focused. Can we have a recording, please? The recording will be available in about a month's time on Legal Cheat. That's what we tend to do. Manageable, challenging, manageable, requires a bit of thinking. Revise, comfort. Yeah, I agree completely. Tricky, says Ellie. Tricky sometimes, says Magda. And I think all the responses are valid because a question's only, it's a bit like watching Mastermind or University Challenge. Sometimes you know the answers and you think you're terrific. But then when you don't, you feel stupid. It's sometimes whether you know it or you don't, or whether you can work out the answer. Sometimes you can, sometimes you can't. And I'm afraid when it comes to the MCQs, sometimes the MCQs that you prepare for won't you won't be necessarily prepared for every MCQ that comes up, whichever course you do, because there's no way of knowing 100% what's going to come up in the exam, which is challenging. But experienced providers like BPP will have you prepared for 99% or thereabouts of the questions that will come up, if not more, because we have very good understanding of how the assessment works. But tell us now in the poll how many you answered correctly, or just do a best guesstimate as to what you answered and how many you answered right. Be good to see. How many did you answer correctly, do you think? Let's have a look at that poll now. Is that poll up there yet? Let me just see if I can see it. Not sure I can see that poll yet. Okay, it's up there now. So none, less than 5, more than 5. You got every question correctly. And it's all anonymous, so don't worry. Tell us how you did. Okay, quite a lot of people have filled in the survey now. That's really interesting in terms of the feedback. I'll show the results actually, which looks quite interesting. That about 2/3 of you got more than 5. Only a couple of you got every question right, which again, well done, exceptional if you managed to remember that. And a few of you will have found that you got very few of them right. I think at the end of the day, it just shows you where this part of your legal education is pitched. But remember, um, this is only a small part of the syllabus. And generally speaking, students do a lot better on these subjects than they do on the practice area subjects. And I think the reason for that is that you've been learning this stuff over a period of 3 or 4 years, and it's been reinforced in your further studies a lot of the time. So you're going to be better at these subjects. However, the practice areas are the ones that are more challenging, and students traditionally perform much worse on those subjects. So don't get a false sense of how you're going to do overall, because you won't probably do as well on the practice areas. But well done, really good answers, and should give you some positive encouragement going forward. So final messages, top tips to access further free SQE MCQs. BPP have got you a link here. So scan that now to access free sample MCQs that BPP have on our website. These are a bunch of criminal MCQs amongst others. Do invest that time, particularly if you're looking to start an SQE course in September, like I said before, in going over your LLB on those core subjects of contract and tort in particular, but also go over constitutional law, land law, and criminal, which we didn't cover in those questions, as well as things like the legal system and amongst others. Try more of the SRA sample questions. All of the ones you saw were in the sample question bank that the SRA have got. I've got a number of these on my website, SQE TV, which I'll give you a link to in a moment. Watch out though for online materials which purport to be SQE standard online. Not all of them are. There's real difference in quality between some that are purported to be SQE standard that are not. And the SRA have told us that they are worried a little bit about some sites that are just springing up with sample MCQs or offering to sell you MCQs of an SRA standard. Unless they are from a reputable provider, I wouldn't touch them with a barge pole. The advice I would say for anyone coming to BPP is you don't need to buy any MCQs outside the ones that BPP provide, because there's 3,000 plus that you have, plus all your course materials. You're going to be entertained, but you do need to practice. And what's really important about MCQs, it's not about whether you got it right, it's whether you got the right answer for the right reasons. And that's why live teaching is so important, whether it's live online or live face-to-face teaching, because if you've got the question right, I can then have a conversation with you and say, justify to me why you got it right. And you might realize that actually you got it right for the wrong reasons. And that's something I can teach you in a live session. It's not something you're going to pick up in a glorified app in quite the same way. So always remember, I think live teaching is the best way to prepare for MCQs, because then you'll learn and prepare for them to the right level. Your choice of SQE provider, I really think, are critical. It does make a difference where you go, not least because when you look at pass rates, and here are BPPs, we've got a huge added value. If you look at the national pass rate, say for January 25, which was 60%, we were 23% above that for our first time sitters when you compare that to the first time sit pass rate. And you can see consistently above that for all those sits, the recent sits. So it does actually pay to go to a provider that gives you that added value compared to the national pass rate. So there we are. What we'll do is we'll deal with any questions. There are a number of questions that we were asked in advance of this session that I'll cover in the networking session. But do, before we invite Legal Sheet back onto the stage, do subscribe to SQE TV, which is my independent channel, which you can access through the link on the slide here. I go through a number of the questions in a lot more detail than I did today, and plenty more other questions besides. Give a lot of advice on qualifying work experience, and also tips in relation to choosing SQE providers from a neutral basis. So hopefully you will become a subscriber. Hopefully you will do, and we'll see me very shortly when we do the networking in the expo room. So I'm just going to see if Legal Sheet want to come on now and just direct you to the networking. Thank you so much, Lydia. Hopefully you enjoyed that. How did you get on, Lydia? I know.
Oh,
No, don't share that. Don't share that.
not too great. I mean, I haven't done an SQE prep course or indeed any legal education, so not too great, but it did make me excited to get started, so that's good. And yes, that brings us to the end of our workshop session. So thanks very much, Johnny, for sharing all your SQE wisdom with us all. As I mentioned in the introduction, we will now be moving on to the networking session, which is going to go on until 6 p.m. The event is not over yet, so please don't go anywhere. You can head over to the networking booths now by clicking on Expo on the sidebar on the left-hand side of your screen, where you can chat with BPP University Law School team for follow-up questions, SQE insights, and further careers advice as well. If any questions come to you after the event, however, you can always rely on our SQE FAQ page on Legal Cheek, in which a huge range of frequently asked student questions have been answered by BPP's SQE experts. So head over to the networking now, and thank you very much for joining us.
Thank you. See you over there. And do put yourselves on camera, because it's nice to have the interactivity that way. See you there in a second.